because they don't want you to act as your own representative. The courts don't want you to act as your own attorney. They want you to use their attorneys. They teach them how to sabotage people, like Fred Miller did and Colleen Starr did. Take a look at my videos of both of them. I'm calling both of them as witnesses in my trial because they have evidence crucial to my defense. They're going to have to explain what kind of scam they pulled, and I've got plenty of evidence videos. Fred Miller, when I was here on June 16th, getting the warrant for my arrest tape lifted, Fred Miller was supposed to be here, and he didn't show. The court told me after that, that Fred Miller has been on the case all along. He didn't show up for court on June 16th. And he said he couldn't make it, and so I showed up here myself, and they tried to arrest me. And then when I got out, I text messaged Fred Miller, and I told him they tried to arrest me, and I said, "You're my witness that John Miller knew all about my car problems, and he had absolutely no reason to swear a warrant out for my arrest." So and he got panicked because I was going to call him. I told him, "You're my witness," and he panicked. So all of a sudden, next time I contacted him, he said, I'm off your case. He says, "I've been fired." And I said, "Who fired you?" And he said, he wouldn't tell me. He said, it's all over, so there's nothing I can do, so good luck. And I kept telling him, "Who fired you?" And then he told me, he says, "It was Judge Holoka." And I'm going, "What?" And then I'm asking him about that, and he says, "Oh, it was the state of Michigan." And then when I'm asking about that, he hung up on me. So I have no idea why he quit, and if it was, he was requested by the state of Michigan. Because the state of Michigan is trying to sabotage my case, because I've gone all the way up to Governor Gretchen Whitmer on the 7-year-old trial that I've gone through. I've gone through 7 years of dealing with this court in Lapeer County when they blew up my house and caused $15,000 worth of damage. Then they signed me up for Social Security Part B against my will, and I never wanted it. I told them I didn't want it. They signed it. They signed me up for it without my signature, without my permission, and over my objections, and just gave it to me that I didn't want. And then now for the rest of my life, I got to pay $176 for something I never wanted, never used, and that's Social Security fraud, and they know it. They know all about that too. And the secretary, when I called Social Security, they told me that I could file a complaint and get my money back, but I had to get a ride up all the way to Port Huron, Michigan, which is like 60 miles from here. And this is when I didn't have a vehicle, so I couldn't get there. So there's no way that I could. No one would help me. No one would take me to Social Security, and I could have gotten my money back that they charged me, but I couldn't get there. And instead of this Lapeer County sabotaging me, all they would have had to do is get me up to Port Huron. And this is another issue that they screwed up with. I'm an Americans with Disability, and the Americans with Disability Act, ADA, states that I have the right to have transportation to access public services, and that's Lapeer Court, and that's also the Social Security. Are you Megan?
Yes.
Oh, did you get my message?
I didn't. I put it on the record.
Oh, I
haven't looked at my.
I thought, I was wondering if you were here.
Oh, yes, I am in the building.
Okay. What should I do?
So let me just go over a couple things. So, here, let's go in one of the conference rooms just so that.
I don't want to leave all my stuff.
I guess I can talk to you in the hallway. It's not a lot of people here, and I'm not going to say anything too sensitive about your case. So today is the final pretrial. So really, it's just to make sure that everyone's kind of on the same page and we know what the expectations are.
No, we're not. We're not on the same book.
We're on the same page in terms of, having a trial date and
trial date that was supposed to be a year ago. You mean?
I know. But they just want to know if they bring in a jury, is everyone going to be ready to go to trial on that day? So.
You know those videos? You know how hard that was? You know how many I got?
How many?
266.
Oh, gee, you told me 180.
That's what I thought. But when I started, what I had to do is I had to drive 25 miles to Walmart to get a external hard drive. So I bought a terabyte one.
Okay.
And that was like $60. If I give that to them, will they download the files and give it back to me?
Probably not, but, you know, usually what happens is everyone maintains their own exhibits after a trial.
Well, can't they just download it? So I can get my drive back? That's all I
Well, so
want.
everyone maintains their own exhibits, which would mean that you would get it back. You would just be in charge of maintaining it.
What do you mean? I just want to know if I get my drive back, because the thing is, if they could download my files right now and give it back to me, I'll just take it back to Walmart. It was like $60 and I don't need it.
Oh, they won't be able to do that because then the court would have to provide an external hard drive. But like it'll be returned to you after the trial.
Right.
You know, it's not going to be like tucked in a court file. So
You know, to be honest, I don't trust them at all, and I've got plenty of right.
Right.
They tried to arrest me on June 16th. I told you about that, didn't I?
Yeah, when Fred Miller didn't
He didn't show up for court.
Right.
And I walked in here and I said, okay, this is to have this, what do they call it, the charge against me, the failure to, swore warrant for my arrest. So I had to have that lifted. So when I walked up in here, Fred Miller mysteriously wasn't there that day. And I had told him, I said, you're my witness that I told John Miller 5 days before that I was having car problems. He knew all about it. But instead of...
Good, you're talking to each other.
she's a good one. She's a
sweetie.
No, you know why? She's not from Lapeer.
Tell you what, don't take advantage of niceness, okay?
No. I don't. You know what?
No, Mr. Schwartz has been great.
We're talking. We're in a battle. We're in a battle of good versus evil in the world right now.
You better get down to business so we can get in there.
Yeah.
Okay. But he set me up, and what he told when I called the court, they said when I called in October, he told me he was fired from the case. He told me that, and he didn't show up for court. He said I was fired, and I said who fired you? He wouldn't tell me. And he said, what was that? It was Judge Holoka. And I said, what are you talking about, Judge Holoka? He says, no, it was the state of Michigan. Then he hung up on me.
Okay.
So I'm telling you something. I believe it could be the state of Michigan, because this Secretary of State, did I tell you about that guy? I've got I want to call two absolute criminal judges. And you got to look at this guy's...
Yeah, so, you know,
I could do that with it.
The prosecutor's office sent me all of this stuff. So, you know, what I kind of drilled down into...
It's too complicated. You've only been here 2 weeks. I don't expect you. This is a nightmare.
I'm good at what I do. So, you know, what really I found most interesting is, you know, they say that one of the elements is resisting, obstructing, causing injury. Now, this is one of their pictures. I'm like, okay, that looks like you smeared some blood. And so there's...
No, you know what it is? These guys are criminals, and they got their buddy.
And I'm like, what even is this?
No,
a little scratch on your arm here?
First of all, I've never harmed anybody in my life. And these guys were armed. Why? How could I?
And I'm like, what even is this?
Right, and how come you got him, but he wouldn't give them to me?
I don't know. I forwarded you the email containing all of this. So you have it's like a 200 and some odd page document or something. So these are pages like 236.
Those are fake. I'll tell you something else. I don't know. I sent you a question. I don't know if you saw it. Can we get a polygraph? I'll take a polygraph test. And I want those 3 cops. I want the chief of police and his 2 clowns that stalked me. They stalked me. They knew I was out of water.
If you really wanted a poly, we could probably get you a poly. I don't know that it would make much of a difference.
They're lying.
And they're not going to take a poly.
Why? I can't force them?
There's just nothing to like compel us to
It's a lie. It's a lie. They made up this whole thing.
There's just not a law that we can say, you know, that requires them to do one.
They lied about it. Everything's a lie, and if we can't get that resolved, I'm gonna get into a fight with this judge, because I had nothing to do with this. I was out of drinking water for 5 days.
Yeah.
And you know, I told you this the day before. I called Lapeer 911.
Oh, and I know. And then I looked through this, and it said that you had empty containers in your car.
Empty? Yeah, I was going there. Right.
Right. I'm like, okay, so yeah, I think he was trying to get some water.
Right. And what they did is, I made so many complaints against Lapeer County employees. They screwed me up. They signed me up for Social Security Part B, and if I live to be 90, and I hope I'll live more than that, that's $65,000 that they cost me. I never wanted it. I never signed for it, and I told them I don't want it. I've got recordings of that. I've got a recording of adult.
Have you worked with any, like, public agencies or anything to try to get your Social Security worked out?
Can I just interrupt 1 second?
Yeah.
Okay. I was just sent out here by the judge. Nothing as a problem, but he just wants to make sure, and I assured him, and you're going to make me look bad if you go back on our word,
No.
that there's going to be no camera, no audio, no GoPro, no audio
Okay.
or anything.
Right.
Okay, and he just gave me the paper. So, and if there's an issue, I know you probably don't want to leave your bag unattended. I'll be happy to personally watch your bag for you in the back hallway, so nothing will happen to it.
Well, I got all my stuff. I got my computer. I got my notes
If
and
you
everything.
need something, I'll retrieve it for you.
But I mean, I got all my files and that too.
Okay, well, I'll tell you what, why don't we do this here? Why don't we do this? How about if I just take possession of the camera and the GoPro for the audio? That way that'll satisfy him. You keep your computers and because you might need them.
Right.
Because you need them for proof last time. I know that. They just sent me out because they know you and I have talked. And you and I have a report, right? I respect
Yeah,
you.
you're a
You respect
human.
me. Right, right. And so that's
You're a decent person.
that's the reason they sent me out, just so I could talk to you on a one-to-one level.
Right.
And so that's the only reason I'm here. I just want to assure the judge that we're not going to have an issue, because he wants to protect your rights as well. Okay?
I haven't had no rights for 7 years with this
We're going to see
county.
if we can't flip this, okay?
Well, we got a new judge and we got a new prosecutor. I'm holding John Miller. You know what John Miller ran on his
Well, I'll tell you what, I can't talk about this thing.
his election campaign? He said he's going to restore law and order to Lapeer County. Is that after this case is over with?
Of course, I can't give you my opinion on that.
I'm going to slap him around.
Well, I'll tell you
I
what.
thought he was my buddy.
He's not allowed to have an opinion
I'm
on
not
these
allowed.
things.
But anyway, as far as can I have the GoPro and the camera?
Yeah.
Okay,
Let me shut it off.
yes, please do. And I'm going to put this in protection in the back hallway, so nothing's going to happen to it. I just want you to know that.
Okay.
And you promise me there's no audio device in any of these bags, correct?
Nope.
You're giving me your honest word, right?
Yep.
Okay. I'm taking you for your word because
Okay.
I believe you.
Okay.
And I don't want to mistrust you because so far you've been a straight shooter.
Don't you think it's, I feel horrible that, let me shut that camera off.
Okay.
I feel horrible that I got to document because I don't trust them. I can't trust them. This,
Well, I'll tell you what, you've got to give this judge a fair shake. This guy, new judge, you got a new attorney. She's
Right.
very nice. She's very sharp.
she's pretty too.
Well, okay, well, I'll tell you what, yes, she is. I do have to do that.
I thought you can't have opinions.
But, well, you know, I'll tell you what, sometimes, but we can't take advantage of that. She's very smart, too. We got to look at her smart, okay?
It doesn't take a genius to figure this out. I mean,
I know.
when you take a look at, you know what?
I'm going to let you guys go back because the judge is waiting on you.
Okay.
Okay?
Okay.
So, now, again, you gave me your word, there's no audio device in any of these.
No.
Okay, thank you.
Okay.
All right. So, you know, one of the things that, so one of the things I found in all of these documents, page 153 and 154, so these are the exhibits and the witnesses who they intend to have at the trial. So, I'll let you have this just so that you don't have
This
to.
is mine?
Yep, so,
Okay. Are they going to have?
this was in that email with the 200 and some odd page attachment, so I'll just give you my copy just so that you don't have to dig through it.
Are the witnesses, is one an EMS? Yeah.
They're right on here.
Here.
So yeah,
Oh.
the two EMS people,
Where is it?
Sandra and
Oh, see, here's-
Robert.
Yeah, you know what they did is, these people showed up after.
Okay.
The people that did
Oh, yeah, you know what they're going to testify to? They're going to testify, oh, we looked at their scratch on their arm and gave them a Band-Aid.
After, no, they didn't even do that. The people that did it was Almont EMTs.
Okay,
That's who did it. And one of the EMTs was Sergeant Robert Parcell. I know that guy.
okay,
And he's a retired sergeant, Almont sergeant, a pothead. And I got a video of that too.
yes.
They just made this whole thing up.
Yeah.
I didn't touch them. And the thing is, when
No, what they're saying is that they were injured because they smashed out your window and then they hurt themselves on the
Both of
window.
them? Both of them?
Yeah, they hurt themselves on the window that they smashed out
Yeah.
on your car.
Right. And when you take
So-
a look at the arrest video, see, another thing is that one of those cops is supposed to have a smartphone video, and I still can't get a copy of that.
Yeah, I don't think I was even given, I don't know if he was even recording though.
No, he did.
Okay.
He recorded. The guy was sitting there. You got to take a look
Yeah.
at the arrest.
So,
Justice, thank you very much for complying. It's a nice guy, okay?
Well, he's new. That's what's good. I mean, that's good.
And I told him you were a nice guy. So don't prove me wrong. Because I know how we got a little, not we, you and Judge Holoka had a little heated exchange.
Yeah, but you know what though? Let me take your life away for 7 years and see how
I agree.
Yeah.
What I'm saying is,
it's hard for me
just
to.
give the honor the benefit of the doubt. You got a new attorney. So when you guys are ready, they're waiting on you. Okay?
Yep, I just want to go over one more thing with him. So the other thing we need to talk about is jury instructions. So these are the instructions that the judge gives to the jury. Technically, because you're representing yourself, that's something that you would have been expected to produce. The prosecutor's office gave us their proposed instructions, and I took a look at them before we came to court today.
When you say instruction, I don't know. What I'm going to tell the jury is,
okay, this is different from like the arguments or anything like this. This is just like instructions about how to be a juror. So, you know, this first one, it starts off, ladies and gentlemen, obviously we're going to have to change some of the names on here. You know, ladies and gentlemen, I'm Judge Nolan, and it is my pleasure and privilege to welcome you to the Lapeer County Circuit Court. The jury is an important part of this court. I think that might be frowned upon. You know, so if you do not hear or understand a question, you should say so. During jury selection, you may be excused from serving on the jury in one of two ways. You know, so these are really routine sorts of things. I looked through these to make sure there wasn't anything weird that they were trying to get into, and there really isn't. These are a lot of procedural sort of things. They're saying that you're presumed innocent, that the burden of the proof is on the prosecutor's office to prove your guilt beyond a reasonable doubt. That you, as you sit here, you don't have to prove anything.
Is John Miller going to prosecute it himself?
I don't think it will be John Miller. I
You
think
know
it's
what?
going to be.
See, this guy was the one, he promised me in June of 2021, he did it right there. He sat down and he said, I'll make you a deal. I'll make this case go away. If you move out of Michigan, don't come back.
Yeah. Well,
and then when I said I want justice, all of a sudden things changed,
yeah.
and he's been my enemy ever since. He was a nice guy. I thought we were getting along. He even told me that Sharkey is a crook. His former prosecutor, Mike Sharkey, is a crook.
Yeah, you know, and so like there's an instruction that says in this case the defendant is representing himself. This fact should not affect your decision in any way. The defendant has the right to represent himself, and he has chosen to exercise that right. A lawyer will have to update that with my name is present if the defendant wishes to consult her. So, you know, these are things. If there was anything, there are definitely cases where, you know, there's instructions. You know, there's a fight of instructions, but
right.
I didn't see anything here that I think
We've got
prejudice you at all.
That's the problem.
So I think we should agree to these proposed instructions.
I could care less. I'm going to say whatever I want because those are my jurors, not them. You know what?
So
I want to tell the story to 12 taxpayers,
Yeah.
and I hope they don't bring pitchforks because these people are they're going to look stupid.
So, you know, we're going to go in there and we're going to, remind the judge that you're representing yourself, that, I did file an appearance, but I'm going to ask that be limited, just, I'm the standby attorney on the case, and that, you're going to be the one, asking questions of the jurors. You're going to be the one.
See, I don't know what I'm supposed to do.
Yeah, so you know what we can do? We can, let's go in there, and then you and I can talk about trial strategy and kind of what you need to do to prepare.
Okay. Now, when's it start?
Next Tuesday.
How am I supposed to serve 3 judges?
Well, you'll need to talk with the judge about who you intend to call as witnesses.
Okay, I've got a whole bunch. It's all state and county employees. This goes all the way up to Governor Gretchen Whitmer.
Yeah, I really think you're going to need to kind of limit your scope to just what happened on this particular day.
This is a culmination. This guy was stalking me. He was waiting right across the street from me because the former prosecutor tried to make a false arrest on me. That's what they did on me.
And I know that there's so much more going on here, but the jurors, all they are going to be able to do is say either guilty or not guilty.
This was a culmination. I had to drive my car because I was out of water for 5.5 days, and I have proof of that.
Right.
How did I get out of water? Because they blew up my water heater and destroyed my house. It's all together. Okay. That's the thing.
Right.
It's not like I just was driving down the street and he just pulled me over. It's not. He was sent there to stop me. He was waiting right across the street. He knew I was out of water because the day before I called Lapeer 911 begging for water and the Human Development Commission. And I recorded both those calls. And I said, please get me water, and I want protection against the Elmont police. That was the day before.
I know. You and I discussed that.
And do you know that I filed a U.S. Justice Department complaint on 8/31/19? That was 1 week before they stalked me. Okay. And I got a copy of that. I filed with Debbie Stabenow. I hired a police abuse specialist. I got all of that.
I know. You told me that too. Right. So let's go into the courtroom, and then you and I can talk trial strategy. And, all of that.
Okay.
Just to be clear.
No.
Schwartz?
Okay. Look at, no, I got.
Is that your walker? Your
Yeah,
plane?
yeah.
Let me carry one of the bags for you.
Yeah, would you mind? He's stronger than me.
Oh, my God.
I brought everything because I didn't want to.
I made that clear to the judge that you have bags because you need proof. He says that's fine.
Hello.
Good afternoon.
You're back on the record.
All right, calling the case of the people in the state of Michigan versus Richard. Case number 20-0-013779. Services for the record, please. Afternoon, Your Honor. I'm Patrick.
Good afternoon, Your Honor. Megan Stammel. I am standby counsel for Mr. Schwartz, who's representing himself.
Well, I don't know that. Ms. Stammel, you have been appointed as Mr. Schwartz's attorney unless there is some compelling reason why you shouldn't be.
No, I don't want. I want to act as my own attorney, and I've been my own attorney for 2.5 years. I had to fire the first court-appointed attorney, Colleen Starr, because she's guilty of malpractice, and I had to fire her in June of 2020, and I told the court that I wanted to act as my own attorney, and I've been trying that ever since, for 2.5 years, and I'm getting nowhere.
Well, sir.
My last court-appointed assistant was Fred Miller, and Fred Miller sabotaged this case. And then he quit, and then he told me that Judge Holoka fired him, and then he told me that the state of Michigan fired him. So I have no idea what's going on.
Well, I can help you with that. We're going to clear that up, but I'm going to need just a moment. Ms. Stammel was appointed as your attorney. If you want to represent yourself, then I need to ask you a series of questions to make sure that I understand and that you are doing so knowingly. So I'll be right back in
Okay.
just a moment.
Okay. Can I get that? Where's that big bag? Because that's got all my files in there. I'll get it. I got it.
Keep your tone down. Okay. You'll get further.
Okay. It's hard when your life has been threatened.
I understand, but he's knocked out.
I know.
Okay.
Well, he seems very nice.
He is. He is. Don't take advantage.
Just remember that today is mostly just a procedural matter, so.
Mhm. Okay.
It's not as though the judge is really going to.
Oh, here's the-
be hearing this court. He's not gonna
here's my
proceed.
hard drive. 266 evidence videos. They can't all be wrong. No, I got. No, that's an external hard drive. It's got 266 evidence videos proving I'm innocent. Oh, here's my list of witnesses.
Is there one of these,
I think I made 2 copies. Yeah.
so can we give a copy of this to the prosecutor?
Hmm?
We can give a copy of this to the prosecutor?
Yeah, I'll give him. I was supposed to bring that.
Yeah, can we give both of these copies?
Yeah,
One
you can
for the
take both of
prosecutor
them.
and one for the judge?
Yep. And then here's a document that I want to enter in. I couldn't put it on the hard drive. And there's the officer that arrested me. Read that. Read what it says. I found his Facebook page. He was laughing about some guy getting killed. He's go, what's it say? Glad the motherfucker's dead. That's his Facebook page. That's the guy that arrested me. This guy isn't capable of being a police officer. He puts good cops in jeopardy. Good cops worse than me, the bad cop. I want to give them that. I hired a police abuse expert, and he filed a complaint. He filed a complaint on 8/31/19, and the Elmont police were supposed to respond to it. So he sent that to them, and he told me that I got to contact them and make sure they got it. And they refused for the whole week. That's why they stalked me. They knew that they got this, and so instead of responding to me, they arrested me, made up a phony charge, stalked me, waiting. They knew that I was out of drinking water for over 5 days, and this.
Okay, so this was filed before
Huh?
your arrest
Yeah,
on the case?
yeah. I filed a complaint against them for police abuse.
and it went to Governor or Senator Gretchen Whitmer's, or no, Senator, what's her name? Senator, can't think of her name. Stabenow. Yeah, see, that's his document he sent to them, and to her, and they were supposed to respond to me. I've got evidence videos of my emails that I sent to them. They wouldn't respond to me. I called them, they wouldn't take my call. So instead of responding to me, Sunday they jumped me, threw me in jail, said I beat up 2 police officers. They put a $100,000 bail on me, a cash bail that I couldn't pay. So I went on a 2-week hunger strike. Did you ever do that?
Oh, geez.
Yeah, I went on a 2-week hunger strike. So then they threw me in a mental institution for 2 more weeks, and all we did is I learned how to play euchre, and they gave me happy pills, and then I threatened them to either let me go or I'm going to go on a hunger strike. So they had to let me go. So I went a whole month. When I got home, my cat was dead. They left my cat died of starvation, but not before it destroyed everything in my house. And then you think I'm not going to be respectful to these criminals. They're not police officers.
I mean, you can definitely have your own beliefs about these officers.
I know what happened.
But just when they come into court and they're on the witness stand, you're going to be judged by the jury in terms of how you react, and the jurors are going to be paying attention to you. So your job is to come in and be the likable guy.
The first thing when they pulled me over, when Ryan Wilson stopped, he was waiting right across the street because the 911 said I was out of water. So he was right across the street. I drove my car without a license. I tried to get. I needed water, so I was in a private subdivision. I wasn't on a public road. He was right across the street. He threw on his lights. I tried to turn around, but I couldn't. I couldn't back because there were people behind me and they were blowing the horn. So I pulled forward and I went right across the street to a parking lot. And he pulled over. He pulled up and he said, "Open the car." And I said, "Get." The first thing he said, the first thing out of my mouth was, "Get your sergeant," because I know his sergeant is Dave Repchus, and he's a good guy. And they didn't send the good guy; they sent this criminal. So and I kept telling him, "Get your sergeant. I'm not opening the door to you." So then his other buddy showed up, Steve Vest, and they're telling me, "Get out of the car. Get out of the car." I said, "Call the state police. I'll surrender to the state police, but I filed a complaint against you. I'm not getting out of this car because I'm afraid of you." And look what they did to me. And then what they did is they falsified this whole thing. When they told me to get out, they broke my window open, and it was real easy. All he did was he took some device, pop, then he reached in. There was no reason for him to. We didn't struggle, so how did he get all torn up like that? And both of them, and so then you can see my video. I said, my legs were locked up. I said, I'm having trouble getting out. He said, "Get out or I'm going to taser you." He tried to taser me in my house 6 months earlier. This is the same cop that says, "Fuck you, I hope you're dead." This guy doesn't, he's a psychopath. And
yeah, I wonder what that was even in response to.
You know what else is, once I took that, those pictures on Facebook, he deleted his account.
Mayor, back on the record.
Great, I apologize for the delay, Mr. Schwartz, I apologize to you. I guess I misunderstood. But
It's not your fault, Your Honor. This is a really complicated case.
I may disagree with you on that. I've looked at the facts, but I need to go over some things with you first, because I need to make sure that if you want to represent yourself at trial, which you've indicated to the court that you do, then I have to go over some things that the Michigan Supreme Court and our Michigan court rules require that I go through with you.
Can I ask you a question, though? I've been my own...
You need to listen to me first.
Just let him go through it,
Okay.
and then you'll have the opportunity to ask questions later.
And so, because you've indicated to the court that you want to represent yourself, certainly you are correct, you have a right to do that very thing. So one of the things that I need to do is I need to make sure, sir, that you are asserting your right to represent yourself because you believe that to be in your best interest. Is that true?
Yes, I don't trust this court, and it's not... You have nothing to do with it because you're brand new. But you got to look at all the evidence. This is a railroad. This is a sabotage.
Okay, you're going to have an opportunity to try your case next week because that's when your case is scheduled for trial. This is what's called a pretrial conference, where we try to get everything ready so it's all set to go to trial next week, because next week we're going to have a jury here. And so it's going to, I mean, it's the real deal next week. So I still need to get through these factors with you. I mean, are you unequivocally telling the court, yes, I, Mr. Schwartz, want to represent myself? Is that true?
Yes, and my question is, I've been my own attorney for 2.5 years. No one's ever said that before. Why didn't Judge Holoka say that to me?
I don't know.
See, that's why I've been sabotaged. That's my point.
Okay,
Yeah, but this judge is trying to do the proper procedure, so
I'm gonna
just give
show
him the
you-
opportunity to do that.
all the respect that you deserve, I expect the same in return, okay?
Mm-hmm.
I'm going to let you speak when it's your opportunity. I need to get through this with you.
Okay.
Okay, and just so you know, because I know you're a person that likes to look up the law, what I'm asking you comes from a case called People versus Anderson. And in
I'm sorry, People what?
versus Anderson.
Uh-huh.
People versus Anderson, the Supreme Court tells people like me that sit as trial court judges, I have to go through these things with you because you need to understand how serious it can be when you represent yourself. And so, the first thing is you told me that, yes, you unequivocally want to represent yourself.
Yes.
That's true, correct?
Yep.
All right, the second thing is that you are asserting your right to represent yourself. You're doing it knowingly, true?
Yes.
You're doing it intelligently. Do you believe that to be in your best interest?
Yes.
You're doing it voluntarily because you think that you can do the best job in presenting your case. Is that true?
Yes.
All right. And that, let me tell you that in the trial of this case, there are what are called rules of evidence. Have you ever heard of the rules of evidence? You're shaking your head no.
No, I don't know what that means.
Okay. Ms. Stamel knows this because she went to law school. And this blue book here, the new one is brown. I didn't grab my new one when I came out here. But these are what are called the Michigan Rules of Court. Within the four walls of this room, litigants have an opportunity to present their case to the court. In your case, you've asked for a jury. But you have to do it sort of according to the rules of the road. The rules of the road in this trial, just like every other trial, means you have to submit your evidence. You call your witnesses and ask questions. You present evidence if you have documents, or I understand you may have some videos. And so they have to meet those witnesses, the questions of the witnesses, the documents or the videos have to meet certain requirements under the law for what are under the rules of evidence. And the rules of evidence are part of the rules that are in this book. And so the rules of evidence tell us that you don't just get to question a witness about anything that you want. It has to be pertinent, it has to be relevant to your case, and it has to have to do with the issues in the case that you're currently involved in. You don't have an opportunity to tell me it's not relevant evidence in your case what you had for lunch yesterday. It doesn't have anything to do with your case. It's not relevant in your case to, if you want to bring in a witness that has something to do with things other than the allegations that are made against you. Do you understand that?
Mm-hmm.
Is that a yes?
Yes, correct.
And I'm going to keep asking you, is that a yes? Because we have to make a record here. And so there are some very complicated rules of evidence. And the reason that we have to go through this with you when you represent yourself is you are bound by these same rules of evidence as if you were, in fact, an attorney. So if you don't know these rules of evidence, it could be really dangerous for you in your defense because you may not be able to ask all of the questions and present all of the evidence that you think you might want to. Do you understand that?
Well, see, that's why the assistant.
Give me an explanation. Yeah, you understand what I'm saying?
Yes.
All right, so you know that there are some risks that go with you representing yourself. Is that a yes? You're nodding your head yes.
I understand. I got no choice though.
Well, you don't have a choice.
No, my last two they sabotaged me. This is the third court-appointed attorney.
I'm trying to help you,
Okay.
and I need you to help me so we can get through this.
Okay.
And so, just so you know, you are bound by the same rules in a courtroom as if you were a lawyer. So you understand that, correct?
Mm-hmm.
Is that a yes?
Yes.
All right. Every time you nod your head yes, I'm going to ask you, is that a yes?
Okay.
Okay? Because we need moral answers. So, again, you do have the right to represent yourself, and it's not easy. Do you understand that?
I got no choice.
Okay.
No, what he's saying is you do have a choice because I could represent you and be your attorney, but he wants to just make sure that it's your choice to.
If I give up my right, I'm giving it. I don't control this trial. I want to control this trial. I'm not going to have somebody tell me what is right or what's wrong. This is a 7-year sabotage from the state, from Lapeer County. It's accumulation that. They blew up my house. They committed Social Security fraud and left me to die without running water. When I tried to get water, these idiots arrested me. And then this has been dragging on ever since.
Okay.
I didn't do anything.
I appreciate that.
Okay.
That is a perfect example of what I'm talking about.
Mm-hmm.
In a trial where it is alleged by the people of the state of Michigan that you resisted an officer, you're not going to get to talk about welfare fraud. It's not relevant. You're not going to get to talk about how you didn't get water given to you. It's not relevant to the case before you. That's why those rules of evidence are really important. because you have to sort of narrow down your case to what it is that we're really here about. And I know you have opinions about other things. I understand that. But it is really dangerous, frankly, for you to represent yourself in this case, because I can see already, despite your best intentions, you're not really going to be able to stay within sort of the rules of the road. And so that brings me to the last part of these factors under the Anderson case. I have to hold you to the same standard as I would a lawyer. And so if you start to ask questions that I don't think are appropriate under the law, I'm going to stop you. And if you continue to go on and continue to ask the questions even when I've told you you can't, and you become disruptive, then I have the right to remove you from the courtroom. I have the right to force you to sit in the back of the room. I have a right to reappoint Ms. Stammel to represent you whether you like it or not, because you can't disrupt the court. You understand that?
That's why I wanted an assistant.
Right.
That's all I wanted. This would work fine for me.
Answer my question first.
Yes.
You understand those things that I've just said to you?
Yes.
All right, so if you become disruptive in representing yourself, or if you ignore the orders of the court, I can put a stop to that. You understand that?
Yes.
All right, and you're willing to abide by those rules?
Yes. I'm a rape victim. I'm not a criminal. And it's up to the court to see my evidence, all the evidence. This isn't me just jumping in my car and starting a fight with two cops. These people stalk me, and you have to look at all the evidence. That's why I've got 266 evidence videos, and John Miller couldn't dispute one of them. He's had my evidence video since January of 2021, and I said, look at my evidence videos, tell me which ones are wrong, and he couldn't. He's had access to them for 2.5 years. He still can't tell me that any of them are wrong. That's why he's not here, and he's got this guy here. John Miller knew all about this, and all of a sudden he's off the case. He was the one that told me in June of 2021, he said, he made me an offer, he said, I will make this case disappear if you move out of the state of Michigan and don't come back. Now, that's why I want John Miller here. Why can't I have him here? He's the one that promised me, not this guy. He doesn't know anything about it. John Miller's had my evidence videos for 2 years. He doesn't dispute them. And this guy doesn't know him. He doesn't know anything about him. John Miller made me that offer. I want to call him as a witness and have him testify to the court why he said that. If I'm guilty, why would the prosecutor make me that offer?
Okay, are you done? It's
Yep.
my turn.
Yep, okay.
Okay, this is another perfect example. And I let you go on for a bit, because I want to have patience with you. We've never met before.
Right.
So I want to have a good dialogue with you, but I need you to understand what we're doing here. And you seem very committed to this, and I appreciate that. But I really need you to understand, this is not a game.
This is not a game. I've become a senior citizen abuse activist. I know the court. I know the law. I understand what was wrong and what was right. And these people failed in the law. They were the ones that disobeyed the law, and then they tried to arrest me for it. I'm sorry. I'm getting upset, and I get heart palpitations and it's all about this. The stress that I've gone through. This dragged on for 43 months. The speedy trial. You're in violation of eight of my constitutional amendment rights. The 1st, the 4th, the 5th, the 6th, the 7th, the 8th, the 13th, and the 14th. You're in violation. It's not a viable court.
All right, Mr. Schwartz, I am about to lose my patience with you.
Okay.
I'm trying not to do that.
Okay.
There's also another article of the Constitution you haven't bothered to mention. That's called Article 3. Do you know what that is?
Article 3, where I can't harbor soldiers in my house?
No.
I'm talking about the amendments.
I'm talking about, well, you want to quote the Constitution. So if
The Constitution was never.
to me,
Yeah.
if you're a constitutional expert, you're going to quote the Constitution.
I'm quoting my Bill of Rights.
I understand the Bill of Rights. I've read them once or twice myself.
Pardon?
I've read the Bill of Rights once or twice myself.
I'm sure you have.
I'm sure I have too. There's this thing called Article 3 that says courts have an actual existence under the law. This court exists. This court does have jurisdiction in your case. And so I'm trying to work with you to give you that speedy trial that you claim you want. You are giving me examples of all of the reasons why this potential trial could be a disaster. Because you won't listen and you go off on tangents. If you are going to do that during the course of the trial with a jury sitting over there, I will stop you. Do you understand that? Do you understand that?
I understand that's what you're telling me.
Oh, I'm more than telling you. I promise you that will happen. Do you understand that?
Yes, I do.
Okay, good.
You're threatening me.
I am not threatening you in any way. I am making sure, or trying to make sure, that you understand your rights and that you knowingly are waiving your right to be represented by an attorney, which is a very important right. Do you understand that?
Yes, I have to. My last two sabotaged me. Take a look at my notes. They're guilty of malpractice. Can I file a complaint against them and call them into court? Because I want the jurors to understand what they did to me.
Here's something I need you to understand. Under People v. Anderson, you need to understand that if you represent yourself, and these are the words from the Michigan Supreme Court, that you will not disrupt, unduly inconvenience, or burden the court in the administration of the court's business. Did you understand those words?
Yes.
All of that is a long-winded way of saying that when we go to trial, we have to follow the rules. I will not allow a trial any other way.
That's fine. If I've got Megan here telling me what I should and shouldn't be doing, we'll get along fine.
Do you understand, sir, that the charges that have been brought against you are 2 counts of assaulting, resisting, and obstructing a police officer causing injury? Do you understand that?
Yes.
Do you understand that the maximum penalty for each count against you is up to 4 years in prison and or a $5,000 fine? Do you understand that?
I thought it was 15 years to life.
From what information I have, it's 4 years and up to $5,000. Do you understand that?
I do now.
Right. Yeah, it is, yeah, now that I flip the page. It's habitualized. Yep, I see the habitual offender notice, fourth offense, and this is good communication. I appreciate that, Mr. Schwartz, you are correct. When I flip the page, I see on the next page that you are charged with being a habitual offender, what's called a fourth offense notice, where it could be up to 15 years, so you are correct. Just need to flip the page. So, even worse, you understand that the maximum penalty for you could be up to 15 years.
Yeah. Yes.
Knowing all of that, it is still your desire to represent yourself.
I've been instructed by a constitutional attorney, John Whitehead of the Rutherford Institute. He's famous. He told me that the worst thing I could do is give up my right to act as my own attorney.
I don't know who that person is, and he's not here in the courtrum, and he doesn't represent you.
I'm just saying.
You told me you represent yourself.
That's why he told me to represent myself.
Okay.
This guy goes on television. John Whitehead, Rutherford Institute.
He's not here. So all I need to know is that you are knowingly representing yourself, correct?
Yes.
All right. That being the case, then Ms. Stamel, you are standby counsel for Mr. Schwartz. Mr. Schwartz, from here on out, you are representing yourself, and unless and until there comes a point in time during the proceedings that you are disruptive, you are basically creating a ruckus in the courtroom, or you won't follow the court's orders. Do you understand that?
Mm-hmm.
Is that a yes?
Yes.
All right, you're going to hear me repeat that over and over and over again. And so with that being the case, then what today is really what's called the final pretrial conference. And so I wanted to make sure that everybody understood that we are in fact scheduled to start trial next Tuesday. And so what we need from you, Mr. Schwartz, I have been handed copies of the proposed jury instructions, because every trial, as far as the court is involved, I'm sort of the referee, and I watch what happens with the witnesses and the questions and those sorts of things. But before we get to that jury trial, every person in your shoes, every litigant, every attorney has to submit to the court in advance of a trial a witness list. And so I have been handed a copy of a witness list, and it begins at the top. It says 3-13-23. Is that something you prepared, Mr. Schwartz?
Is that the one? Yeah. Yes, that's it.
Okay, and it says, I want officers and myself to take polygraph tests to end this trial real quick. That's what you wrote?
Yeah.
Okay.
That's a fair question. And I just added that, and the problem is, sir, I had to make 266 evidence videos that are acceptable to the court, and it took me 4 days, and Megan told me that Thursday, and I worked on it ever since Thursday, and I finished it up this morning, so that list is kind of raggy looking. I apologize. I would have done a better job.
Well, what I need from you, sir, I'm going to hand this back to you. I need you to sign it, because there are rules that govern what happens in courts.
Okay.
If you sign that, that means that you're agreeing that you're bound by those rules.
I got it.
If you would put today's date on there, too, please. And Mr. Schwartz, have you provided a copy of that list to Mr. Fitzpatrick on behalf of the people?
Do you have it?
I have it.
Okay.
All right, very good. And then one of the other requirements is that you provide the people of the state of Michigan and a copy to the court of a proposed exhibit list, not your exhibits, because you talked about videos that you have, but an exhibit list that says what those videos are. Do you have a list?
I didn't understand it that way. It said, the thing is, I made these on YouTube, and this goes up back to 20. Jeez.
Your Honor, if I could just speak to this. Mr. Schwartz did advise me that he has, is it 266 videos that are on his YouTube channel that he wished to introduce as exhibits. I had explained to him that it wouldn't be appropriate to introduce a link as an exhibit and that he would need some type of hard copy. So he has been diligently working on getting those videos onto an external hard drive so that there would be some type of tangible hard copy of the exhibits that he wishes to introduce. I do not believe he prepared a physical list of what those videos are.
All it is a chronological list that goes back to where this all started.
Well, the allegations in the felony warrant that was originally issued against you indicates that the events that are involved in this case occurred on September 8th of 2019.
Right.
So, I mean, videos prior to September 8th of 2019 wouldn't be relevant.
That's all relevant. It's all relevant because this is a culmination. They arrested me. This was a culmination of me making complaints about Lapeer County employees' gross negligence. They destroyed my house, did $15,000 worth of damage, and signed me up for Social Security Part B against my will and without a signature. And between those, they did $15,000 worth of damage. And if I live to be 90 years old, the Part B will cost me $65,000 that I never wanted. And that's how this all started out in 2017. And I started having, they blew up my house, cut me off. I had no drinking water for 2.5 years. They destroyed my house and tried to cover it up. That's what it was. It was a cover up. And the former prosecutor, Mike Sharkey, tried to cover it up and wouldn't let you. You cannot make a complaint against a Lapeer County employee. They make it impossible to do it. And I tried. I don't want to get in trouble again.
And Your Honor, in speaking with Mr. Schwartz, I think what he's really trying to explain is that there's kind of a greater history and that this history affected the conduct of the police officers on the date of this alleged incident. That he alleges he was unfairly targeted by the police and that their motivations were impure because of these other previous events. Is that fair, Mr. Schwartz?
Mm-hmm.
And so that is what he wants the jury to be able to understand as it would go towards the bias of the witnesses.
There we go. That's something I understand.
And see, I also went.
My turn.
Okay.
So you may have all of these videos that you want to try to introduce.